Hi, everyone. So, this is part two of topic 2.9, slavery and American law. Last time we looked at some slave codes and saw how laws were used to prevent resistance and keep enslaved people in subjection. And today we're going to look at how the law, including the Constitution and the rulings of the Supreme Court, continued to impact the lives of Black Americans well into the 19th century. We've been jumping around a lot in this unit, so let's use a timeline to see how everything fits together. The first thing on here is Juan Garrido, the Ladino conquistador, who was probably the first African in North America. In 1670, we have the founding of Charleston, South Carolina, which we learned became a major hub for the slave trade. Almost half of the 388,000 African prisoners brought to North America were sold there. And then we have the two documents we looked at yesterday, the slave codes of Louisiana and South Carolina. The Louisiana one is called Code Noir because that's French for black code, and Louisiana was a French colony until 1803. Those documents revealed increased fear of slave revolts among colonial governments and introduced greater restrictions on the freedom of the enslaved to meet with each other or move around. They also gave a pretty universal authority to whites to arrest and punish unescorted black travelers. In the rest of this lesson, we'll track the legal situation for enslaved black people over the next 120 years or so and find out what the Constitution had to say about slavery, as well as how the intentions of its authors were interpreted by the Supreme Court in one of its most infamous decisions regarding the citizenship status of an African American slave named Dred Scott. And by that point, we're going to be very close to the Civil War. So we're going to need a little background in the Constitution to understand this next bit. So here's your 60-second crash course. The Constitution is a written document that says how the U.S. will be governed. It separates the federal government into three branches. The legislative branch writes laws, the executive branch enforces laws and is led by the president, and the judicial branch interprets and reviews laws and is made up of several federal courts, the highest of which is the Supreme Court. In the executive and judicial branches, the president is the only elected official, but the legislative branch is entirely made up of elected officials. This large group of elected lawmakers make up Congress, which has two parts, the Senate and the House of Representatives. Laws are made in Congress based on votes cast by these elected lawmakers, and each of them is elected to represent a specific state. Each state is guaranteed at least one vote and therefore one representative, but not all states are the same. At the Constitutional Convention, delegates from Virginia proposed that states with larger populations should have more votes, since more people would be affected by federal law there. But smaller states, like New Jersey, objected. They knew that with only a quarter of Virginia's population, they would be easily outvoted if congressional representatives were based solely on population. So they proposed a different plan: one state, one vote. The big states and the little states couldn't agree until someone said, why not have both? So that's what they did. Congress would have two chambers, the Senate and the House of Representatives. In the Senate, each state gets the same number of votes, which is two, and in the House of Representatives, states with higher populations get more votes. And laws have to pass both chambers, so having more people is still an advantage, but not a huge one. But wait, time out, says New Jersey. Virginia does have a large population, but a lot of them are enslaved people. And everybody knows they're considered property and not people, so why do they count for Virginia's population? Of course, slave states like Virginia were really jazzed to be able to exploit their personal chattel for political as well as economic gain, but in the end, it was decided that only 60% of the enslaved population would count. And in the final analysis, the southern states did pretty well turning their enslaved populations into outsized influence in federal legislation. 70 years later, a case came before the Supreme Court that asked whether African Americans could become citizens with rights protected by the Constitution. It's known as the Dred Scott decision. Here's what happened. Dred Scott was an enslaved man who belonged to multiple slave owners in and around the state of Missouri. At one point, his owner moved him to Illinois. which didn't allow slavery, and later to an unincorporated part of the Midwest that eventually became Minnesota. Dred Scott's legal argument was that by bringing him into states and territories where slavery did not exist, Dred Scott's owner should have lost ownership of him, and that living on free soil made him free. The case ended up before the Supreme Court in 1857. The opinion of the court was written by Chief Justice Roger Taney. It drew into question whether Scott even had the legal standing to file the lawsuit in the first place. It stated that the framers of the Constitution clearly did not intend for black people to have a share in the governing of the country, as they were considered inferior and subhuman by the entire civilized world at the time. Therefore, it was ridiculous to think that black people could be citizens, and Dred Scott had no rights that the court could consider. This was not the ruling abolitionists were hoping for, but the court went further, stating that the Constitution clearly recognized chattel slavery as a legal right to property ownership for its citizens, and that no state had the authority to infringe that right, which meant that there was no legal basis for free states at all, and that slave owners could, in principle, maintain ownership of their chattel anywhere in the country. The ruling seemed to be a major victory for enslavers and infuriated many in the North. The situation was coming to a head, and within 4 years, the country would be at war with itself.